How do you deal with this restitution argument? That's sort of the crux of what we're talking about here.
That's true. And quite simply, the Seventh Circuit properly recognized in the Janus and Mooney decisions that plaintiffs here are not seeking the equitable return of property, no matter what they contend before this court. Plaintiffs are seeking a legal remedy. Namely, they're seeking damages for the violation of their First Amendment rights. As Judge Nguyen recognized, the claim here is premised on the First Amendment. It's premised on the use of plaintiffs' funds to support expressive activities with which they disagree. That is the right against compelled association and compelled speech that was recognized in Janus, and that's at issue in this case. If plaintiffs' money had been taken and held by their public employer or by the union and not used in a manner that implicated their expressive activities to which they objected, there would be no First Amendment issue. But in this case, we are here on a First Amendment claim, not a property claim. And that's just that, so they are pursuing a damages remedy for that First Amendment right. Furthermore,
would you also contend that the restitution remedy simply doesn't fit here because you cannot return the services the union provided with respect to the payments that were received?
Absolutely, absolutely. There are actually two pieces of that I want to point out that make the claim that they're making about the relief they're seeking an opposite. The first is that the money that was paid, the fees that were paid, has already been spent. It was spent by the union in providing ongoing representation to all members of the bargaining unit. This is not a case where there is property, either intangible or tangible, that belonged to the plaintiffs that is in the defendant's possession that they're seeking to retake. The money has been spent, and what they are seeking is an award of damages or money from the general assets of the union. And this court recognized just this term in the Depot Incorporated versus Caring for Montanans decision, and the Supreme Court has emphasized that kind of monetary relief against a defendant's general assets is a legal remedy. It's not an equitable remedy of any kind. But as Your Honor points out, even if they were seeking an equitable remedy, the equities here would not support the kind of relief that they're seeking. Because for the reason you've pointed out, the union did provide representation to the people who are now seeking the repayment here. The union can't take that payment back. At the time fair share fees were lawful under binding Supreme Court precedent, the union made a choice about how to allocate its costs of collective bargaining across the entire bargaining unit and did so consistent with the law at the time, and then it provided representation using those funds. The funds are gone, the representation has been provided, and that egg can't be unscrambled retrospectively. And the Supreme Court, in the Davis case and the Lemon II case, have emphasized how important those reliance interests are in thinking about whether the equities would support relief.